I said we could turn it red behind you and make you do a dictator speech for the... I got that on camera.
Ever wish you could grab a beer and ask a lawyer any question you wanted and have him break it down for you? Law Splaining at GRL Raw breaks down fancified legal mumbo jumbo over beers so all may understand. Okay, welcome back. GRL's Law Splaining, where we break down fancified legal stuff over beers and try to make it relatable and understandable for everybody. On this episode of Law Splaining, we are going to tackle what turns out to be a law nerd fascinating issue of government officials and social media. In line with GRL Raw, we are going to have a solid dose of First Amendment on this. It goes back to last year where we had a couple episodes on that. And you're sitting there listening to this before you find a different podcast. Let me tell you why you should care. So let's make it relatable to all of us. Let's say there's a government official who has a social media page. You as a citizen may be friends with them, maybe followers with them, and you're not enjoying or happy with how they're doing their job. So you take to, let's just say, Facebook, and you type up comments, tasteful of course, but dissenting comments on how they're doing their job. You post it on their page or you reply to one of their posts, and much to your dissatisfaction, it gets deleted. Well, that's bull, okay? So you post it again. They delete it again. This is un-American, you're upset. You post it again. This time they delete it, and when you try to go back, you are blocked. You can't post anything on this person's page. Well, we know from last year, season 2 of GRL Raw, that the First Amendment prohibits the government from interfering with what? Free speech and free expression of opinions. If the person is a government official, they're censoring your expression or your speech. Arguably, that's a violation of the First Amendment. Enter the most recent United States Supreme Court decision as it relates to the First Amendment. It's called Lindke, Lindke versus Freed, Freed. It kind of gave us some information on how these questions get addressed and what framework that a court has to use to review this type of action. In this case, Mr. Freed, got sued, was a city manager. He initially started a personal Facebook page. He was a popular dude. People liked him. He was a public official. And he reached that 5,000 followers mark and had to move to the public figure status within Facebook. He continued to use Facebook for personal reasons, all kinds of stories about his, as most of us do, our pets, our kids, personal endeavors, that kind of thing. But he would also post from time to time related to his job as city manager, city stuff. So Mr. Freed, so this is backwards. I had it wrong. Mr. Freed posted his opinions on how the old city manager was doing. City manager deleted it. He posted again. City manager deleted it. And ultimately, the guy got blocked from posting on the city manager's site. So, as we do in America, he sued the city manager, saying that the city manager was improperly interfering with his First Amendment right to express himself, to dissent against the government's conduct. As we've explored before, the federal law allows a citizen to sue a person who's in a government capacity, who under the authority given to them by that position in the government, deprives somebody or interferes with their exercise of a constitutional right. As we've also talked about in the past, the first step in deciding if there's a case that can be brought under this cause of action is, was there government conduct? Was there a government actor? Or was it conduct of a private citizen? Because the law only protects against the government infringing on somebody's rights. Personal, private conduct that arguably mutes or interferes with a constitutional right is not something that you can bring a cause of action for under this 1983, is 42 USC 1983 cause of action. For example, in our homes, my kids do not have freedom of speech. The Fifth Amendment, the right against self-incrimination, does not apply. The Fourth Amendment, right against unreasonable searches and seizures, does not apply as it relates to me doing things to them. I can interrogate them, I can search their rooms, I can look through their phones, and I will and do that. They can't sue me for that. If they do, they're going to lose and probably get grounded for the rest of their life. So with this case, with this fact pattern, it had never been addressed uniformly. So there's 9, 10 different circuits of federal courts. Each one kind of had a different application of how they evaluate this issue. And there's an important twist. Even public figures, even representatives of government in their private lives have constitutional rights, believe it or not. The governor of Iowa, when involved in her private life, has constitutional rights, has the ability to speak her mind, has her ability to express herself without recourse. But when she's acting on behalf of the government in her capacity as the governor and she speaks, now she's acting as a government voice and as a government actor. One analogy that the Supreme Court used in this case was, let's say you have a school board president. And at the end of a school board meeting, the school board president gives a statement on behalf of the school district, on behalf of the school board. That is acting as a government actor. Now, that same person goes and has a barbecue and is talking to his friends about his opinions, or anybody else about his opinions in his backyard as he's cooking up the chicken and steaks. At that point, he's no longer speaking as the government actor, he's speaking as an individual person, and he's entitled to express whatever he wants in that situation. So they came up with a test to determine whether or not there's government conduct in this type of setting. First, it is government action if the individual has actual authority to speak on the government's behalf. If you're in Iowa, in particular, the Des Moines area, the analogy that came to my mind is the spokesperson for the Des Moines Police Department. Right? When he's all uniformed up and he's given a statement on behalf of the Des Moines Police Department, he is a government actor. But if you run into him at, say, a baseball game and you're having beers with him and he's speaking outside of that, he's not in uniform, especially if he's having beers, then at that point in time, he's not speaking on behalf of the government entity. If it's in your job description to speak and to share that information in that context, then there is kind of a presumption that you're speaking on behalf of the government. If it's not in your job description, if you're just yapping to yap, or you're kind of talking outside of your scope of employment, then it's not going to qualify more than likely as government action. The next step, if you pass step 1, step 2 is the person is speaking as if they are exercising that authority when they're saying what they're saying. So it's not just who says it and under what conditions, it's what they say and how they say it is going to make an important impact on this whole weighing of the, that's a terrible way to say it. It's going to matter that way, okay? We're law splaining. Gonna have some bush lights here. So, enter social media. If the account, for example, if I have an account and it's Bobby Rehkemper Facebook account, and I am speaking strictly my personal opinions, and I don't post anything business related, I'm not posting on, I don't have a job within the government, nothing I say can ever be attributed to the government. It's that simple. Keep personal, And if you're a government employee, say you're the city manager, if all your posts on social media are personal, under your personal account, you have nothing to fear. You can speak your mind. But if you start going down the road of speaking on behalf of the government or posting or reposting notices, road closures, liquor license violations, that kind of thing, now you're treading on that uncertain ground of you could be speaking on behalf of the government. If it is a government account, for example, city manager of West Des Moines account, and it passes from city manager to city manager, you're always speaking on behalf of the government. Anything you say, anything you do, if you're editing comments, if you're deleting people, if you're blocking people, that is government conduct. You get yourself in hot water when you start censoring. Those in-between cases are the trick. And they also mentioned an interesting part. There's a difference between deleting comments to a particular post and a flat-out ban on posting. It'll be, if you're deleting comments on a post, it's a post-by-post analysis, if that makes sense. So it's, I hate the Cubs. Okay, that's probably a personal post. You can delete away all you want. If it's the Iowa Cubs are an important part of the economic development of the city of Des Moines, and anybody who says otherwise is a bad person, and you start deleting posts commenting on that, and you're the city manager, within that post, that's probably going to be improperly restricting and interfering with freedom of speech. A flat ban creates a whole new issue. So if you ban somebody and you're on that either or continuum, like some of your comments may be government related, some of them may be personal. If you ban somebody altogether, you're prohibiting them from even commenting on government information. Now you're going to run into First Amendment problems. One easy way to do it, keep personal personal, business business, or within your personal site, you can say the old disclaimer, the views expressed by me are individual to me and have no application to my government position. So, generally speaking, in this case, Mr. Linke, probably going to be okay. The city manager is going to be okay. There was a companion case that came down with the school board officials who had school board official social media sites. They're going to be in trouble when this all comes down. So, simply put, keep business business, keep personal personal. Don't mess with people's freedom of speech unless you're doing it on a personal capacity.
So, with that, what constitutes a government official when, as a sports nut, there are athletic directors out there that have blocked fans from accounts, that type of thing. They are a state employee, technically, I believe.
That would be a state actor. So a state actor is anybody whose employment, or government actor as well. So you'll have state actors who are employees of the state, city actors who are cities of the city or employees of the city. If they're employed and paid by government, they're going to be considered state actors. So an athletic director who is posting or is regulating comments and communications as it relates to their posts or school-related posts, as long as those comments are within certain bounds of taste, right, for schools, they're stepping over the line and they're opening themselves way up.
Interesting. Mm-hmm. That was my only question.
Look at us. Short, sweet, law splaining at its best. See you next time.